Good morning.
Good morning, Your Honor.
All right, let's just start at the top and we'll go through these, and then I think we have one that they're still working on. So we'll do Laria Eccles.
Step right over to this.
All right. So we'll call the case of docket. This is a brand new case. Ma'am, you are Laria Nikkei Eccles. And you can hear me all right, Miss Eccles?
Yes.
Okay. Mr. Sarts, your appearance for the record.
Good afternoon, Your Honor. Jacob Sarts IV, Assistant Public Defender, here on behalf of Miss Eccles for this arraignment this morning.
All right, this is the time set for an arraignment. Ma'am, I'm going to indicate to you the nature of the charges that have been alleged against you, and then I'll have some questions for you, and I'll read you some rights in regards to this misdemeanor file. Do you understand that, ma'am?
Yes.
All right, thank you. It is alleged that on February 25th, 2023, at the offense location of 3051 Trappers Cove Trail, City of Lansing, Ingham County, yourself, Laria Nikkei Eccles, did in count one make an assault and or assault and battery upon Devin Hopkins, a resident or former resident of her household, or an individual with whom she had a dating relationship. Contrary to the law of the state of Michigan, that being MCL 750.81, parents 2. Restitution may result in damage to another individual's property or physical injury or death pursuant to 780.811A. So it may be ordered in this case. This is a misdemeanor, 93 days and or $500. There may be a consecutive sentence may be imposed under the laws of the state of Michigan if the assault was committed in a place of confinement. Do you understand the nature of the charges that have been alleged against you, Ms. Eccles?
Yes.
All right. I'm going to read you some rights you have in this misdemeanor case. You have the right to have a trial by jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have those witnesses against you appear at trial. You have the right to question the witnesses who are brought against you. You are represented today by Mr. Flores, Mr. Sarts, for just purposes of arraignment only. Do you plan to seek additional representation from the public defender's office, ma'am?
No.
Do you plan to seek your own counsel or to stay with the public defender in regard to this office, in regard to this file?
I'm gonna stay with them.
All right, so I'm gonna indicate for the register of actions that you do plan to seek representation from the public defender's office.
Correct, Your Honor, and we request the court enter a plea not guilty on her behalf. Thank you.
Okay, thank you. 27. All right, you have the right to remain silent during a trial. You have the right to have the court order any witnesses that may be needed to appear for your defense. You have the right to have the silence, not to have silence used against you in the court of law, and you have the right to testify at trial if you choose to testify. Do you understand your misdemeanor rights in this case, ma'am?
Yes.
All right, your next hearing date in this matter is set for, it's a pretrial conference. And it's set for March 20th at 10:30 in front of Judge Simmons.
Okay.
Do you have a current address and phone number in order to put in the court file, Ms. Eccles?
3051 Trappers Cove.
All right, that is the place of the incident. Do you have another place that you could actually get your mail, because there's going to be a no contact order with that place?
No.
All right. So for an address, so there's going to be a no contact order with 3051 Trappers Cove, which is the where the incident took place. Do you understand that, ma'am?
Yes.
All right. So address is to be determined. Do you have a phone number?
I don't remember my number, sorry.
You don't know what your phone, okay. So phone numbers to be determined. Are you on probation or parole?
No,
Are you employed?
yes.
And where are you employed, ma'am?
Bright Star Care.
Say it again for me.
Bright Star Care.
Right Start Care. All right, I'm gonna automatically enter a not guilty plea as indicated from your public defender. Counsel, would you like to be heard on bond?
Thank you, Your Honor. This is a somewhat complicated situation because Ms. Eccles, just moved here within the last few years. But to her credit, to the best of my knowledge, and based on what Ms. Eccles has told me, she doesn't have a history with the criminal justice system at all. She has no previous issues with court dates or failing to appear or anything along those lines. She does have friends in the community. She does not have any immediate family in the community, but if given sufficient time, certainly she can establish a residence or a place to stay temporarily while this case proceeds. In terms of her phone, she does have a working phone. As she explained to Your Honor, it's just simply a matter of remembering her new number, and she'll certainly be able to update the court. She does have a job in the healthcare field. So, if she's released, she would have a stable place to work, and she can make arrangements for a place to stay. So given the potential complications here, but given her lack of history, I would request, Your Honor, that Your Honor consider a personal recognizance bond for her. And that's based on, from what I understand, is her lack of history here. And she should be able to find a new place to stay temporarily while this case proceeds. Once she's able to be released, it's going to be a little tricky for her to make those arrangements currently. Thank you, Your Honor.
Thank you. All right, ma'am, if you're able to make bond or able to get out, I'm going to place the following conditions. The GPS is ordered for 1,500 feet with exclusion zone of the victim. No assaultive, no use of alcohol or drugs. No out-of-state travel. No contact with the victim. And the victim in the case is Devin Hopkins. So that's where Devin Hopkins lives, works, or goes to school. You're to stay 1,500 feet. And that onus is on you. No possession of a firearm. I'm going to set back. I do agree with Mr. Sartz. You have no criminal history, ma'am. So there's no criminal history to speak of, at least on your lien information. This is an assaultive crime. It's a domestic assault. So I'm not going to issue a PR bond for an assaultive crime, but I will issue a $200 cash or surety for the case. If you're able to get out, all the bond conditions that I've indicated apply. Anything else for the record on docket on Ms. Eccles' case Mr. Sarks.
Nothing further, Your Honor. Thank you.
All right, thank you. Miss Eccles, you're all set, all right?
Thank you.
Thank you. And then we're on the record in docket. It's Mr. Morales, Mireles. All right, this is a new case. Sir, you are William James Morales.
Yes.
All right. And Mr. Sarts, your appearance for the record.
Good afternoon, Your Honor. Jacob Sarts, IV, Assistant Public Defender, here on behalf of Mr. Morales for this arraignment and this arraignment only.
All right, thank you. This is the time set for an arraignment in the matter. Mr. Morales, I'm going to read you the charges that have been alleged against you, and then I'll walk you through some rights you have in this misdemeanor charge. All right, sir?
Yes.
All right. It is alleged that on February 26, 2023, at the fence location of 1112 Ontario Street, City of Lansing, Ingham County, State of Michigan, yourself, William James Morales, did make an assault or an assault and battery upon Erica Morales, a resident or former resident of his household, or his spouse, or an individual with whom he had a dating relationship. Contrary to the laws of the state of Michigan, that being MCL 750.81 parents 2. Restitution, this offense resulted, if this offense resulted in damage to another individual's property or physical injury or death, restitution may be ordered pursuant to the laws of the state of Michigan. That's 780.811A. This is a misdemeanor, 93 days and or $500. There's a second offense notice, so I'll indicate that for the record also. A consecutive sentence may be imposed under the laws of the state of Michigan if the assault was committed in place of confinement. There's a second offense notice, sir. Take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or resident or former resident of his household, or knowingly assaulting a pregnant individual, contrary to the law of the state of Michigan. They were convicted on January 5th of 2000, and therefore upon conviction, you may be sentenced to an enhanced sentence, that making this a 1-year misdemeanor and or $1,000. Consecutive sentence may be imposed under the laws of the state of Michigan if this happened in a place of confinement. Sir, do you understand the nature of the charges that have been brought against you?
On the old one, I don't remember the old one was. That was like an old, I don't remember that.
Correct.
It was about.
The only thing that does is it enhances the sentence that you may be facing, okay?
Oh.
All right. So, and I have that as out of January 5th, 2000. This is a misdemeanor case because it's punishable by under a year, and therefore I'm going to read you your following rights in this misdemeanor case. So you have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses. You are represented today by Jacob Sarts from the Public Defender's Office in regards to this arraignment only. Do you plan to seek further representation from the Public Defender's Office in this file?
Yes.
All right. I'm going to indicate a yes for the Public Defender's Office for this file. You have the right to have the court order any witnesses to appear at trial in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand the nature of these rights in this misdemeanor case, sir?
Yes.
Do you have your next date in this matter is March 14th. Is March 14th, 2023 at 9:30 in front of Judge Buchanan. Do you have a current address? Do you have a current address in the matter? I have an address for you of 6267 Marywood, which is not the location of the offense. Is that a good address for you, sir?
Yes.
And do you have a phone number that's a good contact number for you?
517-918.
517. Go ahead.
517-918-9268.
517-918-9268.
Correct.
Are you on probation or parole?
No.
Are you employed, sir?
Yes.
Where are you employed?
Meyer Warehouse.
All right, I'll automatically enter a not guilty plea for purposes of this arraignment. Mr. Sartz, would you like to be heard on bond?
Thank you, Your Honor. Respectfully, I would request a personal recognizance bond on behalf of Mr. Morales. He's not a flight risk at all. He has deep roots in the community. Notably, his parents live here and he would be living with his parents. He can keep a safe distance away from the complaining witness here. He's been advised at length about the no contact order. He understands the importance of complying with that order. He has a good, stable job in the area, working for Meyer Warehouse. It's full-time. And respectfully, Your Honor, given the charges, while the charges are of the assaultive variety, the previous conviction goes back to 2020. So, to the best of my knowledge, Mr. Morales does not have much exposure to the criminal justice system outside of that charge, or possibly some cases that are even predate that. So given the circumstances, given his strong connections to the community, given his lack of flight risk, I would respectfully request a personal recognizance bond. Thank you.
Thank you. All right, I'm going to treat this. I'm uncertain about the second offense notice. First of all, let's get to the, if you're able to make bond, these are the following bond conditions. There's a GPS, no contact with the residents of 112. So GPS exclusion as to place of the event of the assault. And that's the exclusion zone concerning 112 Ontario Street, City of Lansing. There will be no assaultive behavior, no use of drugs or alcohol, no out-of-state travel, no contact with the victim, and the victim in this case is Erica Marillis. And that would be 1,500 feet from Marillis, where they live, their school, or their place of business. And the onus is on you to protect yourself, to stay outside of that 1,500 feet zone. There is no possession of a firearm. That no contact also is direct or indirect. I'm going to treat this right now because of the way it's issued. There's a second offense notice for January 5th, 2000. But as I look at the prior CCH, I don't have that as a, I don't have the January 5th, 2000. I have that assault as being dismissed out of that date. So I'm going to treat it as a first for our purposes right now. So I'm going to set bond on this case. It's an assaultive crime. So I will set a bond on this case. It'll be $300, 10%. So that'll be a cash bond. I'm sorry, $3,000, 10%. I misspoke there. $3,000, 10%, on this assaultive crime. So it's 10% of $3,000 in order to get out. You'll be under your bond conditions. Anything else for the record, Mr. Sartz?
Nothing further, Your Honor. Thank you.
Okay, thank you. Mr. Morales, you're all set.
Thank you.
I gotta sign this one too. All right, so we're on the record in, this is Michael Johnson, which is a felony case. And sir, you are Michael Johnson? Michael
Yes, sir.
Atron Johnson? All right.
Yes,
Counsel, your appearance for the record?
Good afternoon, Your Honor. Jacob Sartz, IV Assistant Public Defender, here on behalf of Mr. Johnson for this arraignment and this arraignment only.
All right. Mr. Johnson, this is the date of the arraignment. I'm going to walk you through the complaint charges that have been alleged against you. And then I'm going to walk you through some of your rights in this felony charge. All right, sir?
yes, Your Honor.
All right. So it's the complaint alleges that on or about February 25th, 2023, at the offense of North Pine Street, West Oakland, City of Lansing, Ingham County, the defendant Michael Atron Johnson did make an assault upon Lisa Lee with a dangerous weapon, to it a knife, but without intending to commit the crime of murder or inflict great bodily harm less than the crime of murder. Contrary to MCL 750.82, this is a felony, 4 years under $2,000. DNA may be taken upon arrest. A consecutive sentence may be imposed under the laws of the state of Michigan if the assault was committed in a place of confinement. The prosecutor's office has also charged in the alternative to count one, count two, did make an assault or an assault and battery upon Lisa Lee, an individual with whom he had a child in common, or an individual with whom he had a dating relationship. It's contrary to the law of the state of Michigan, 750.81 parents 2. Restitution may be ordered if there was damage to an individual's property or physical injury to or death to another. This alternative count is a misdemeanor, 93 days and or $500. A consecutive sentence may be imposed under 750.506A if the assault was committed in a place of confinement. Mr. Johnson, do you understand the nature of the allegations that have been brought against you?
Yes, Your Honor.
All right. In this felony charge, you have the following rights. Here, these are your trial rights I'll walk you through. You have the right to be tried by jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial and testify. You have the right to question those witnesses. You have the right for the court to order any witnesses you may have for your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand the nature of your felony rights, sir?
Yes, Your Honor.
You are represented today by Attorney Jacob Sartz from the Public Defender's Office. For this arraignment only, do you plan on seeking additional representation from the Public Defender's Office in regards to this file?
Yes, Your Honor.
All right. So I'll indicate for the registered actions that that Public Defender's Office is your intent. Do you also have the right in district court to a probable cause examination? That's an examination to be held within 21 days of your date of arrest. So it'd be within 21 days of today. A probable cause hearing is a preliminary examination. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime was committed and the identity of the person committed that crime. You'd be able to be represented by counsel in that case. Do you understand the nature of that district court preliminary examination right in this case, sir?
Yes, Your Honor.
All right. I have your next date is a probable cause conference in front of Judge Simmons on March 9th, 2023 at 8:30. And then I have a preliminary examination date, which would be in person. The probable cause conference may be by Zoom, but the preliminary examination is in person, and that's March 16th, 2023 at 8:30 in front of Judge Simmons. Do you have a current phone number? I'm sorry, do you have a current address that there's going to be a no contact order with Miss Lee? Do you have a current address that you can receive notice and information that is not the address of Miss Lee?
Yes, Your Honor.
And what address is that, sir?
540 West Willow Street, apartment D22.
All right. What was that apartment again?
D22.
Okay. That's Lansing, Michigan, 48906?
Yes, Your Honor.
All right. And do you have a phone that you can be reached at for the court file?
No, but I can give you my sister's.
All right, that'll work. Sister's phone?
517 619
right.
4946.
Thank you.
You're welcome, Your Honor.
Are you on probation or parole?
No, Your Honor.
All right. Are you employed at this time?
No, Your Honor.
I'll automatically enter a not guilty plea for purposes of this arraignment. Mr. Sarts, would you like to be heard on bond?
Thank you, Your Honor. I'm sorry, Mr. Johnson, what was that phone number again?
517 619 4946.
4946, thank you. Your Honor, respectfully, I would ask for a personal recognizance bond on behalf of Mr. Johnson. Mr. Johnson is not a flight risk. He has lived in the community for approximately 8 years. His mother lives here, his sister lives here. To the best of my knowledge, for the most part, he's had a pretty good track record of appearing for court dates, albeit he did have some issues with the case previously, but his family's here. He's trying to find a job currently, but he's not a flight risk, and he'll appear at all his court dates and follow with the court's orders. Thank you.
Thank you. In regards to the bond, if you're able to make bond, I'll set the following conditions. I'm going to order a GPS tether to be ordered in an exclusion zone. And that exclusion zone would be the place of incident here. Well, this started earlier. So 8:30, so it'd be the 8:30, it'd be North Pine Street, West Oakland, 8:30 North Pine Street, West Oakland. So that'll be an exclusion zone as part of the GPS. The no use of alcohol or drugs without prescription, no assaultive behavior, no out-of-state travel, no contact with the victim, Lisa Lee. That's 1,500 feet of place of where Miss Lee is, including place of business, work, and school. That includes all places of work, business, and school. No possession of a firearm. And you are to report to 48 hours, you are report to pretrial services within 48 hours of release on this felony. I've looked at so this is a felony count, 4 years. It's also an alternative in the misdemeanor count. I've looked at the prior criminal history, which is limited in regards to convictions. There's a retail fraud out of 2013. There does seem to be some history of domestic assault without any type of conviction. This is a felony count. So I would place bond at 5,000, 10%. Anything else for the record in concerning Mr. Johnson, Mr. Sartz?
Nothing further, Your Honor. Thank you.
All right, Mr. Johnson, you're all set. Thank you.
You're welcome, Your Honor.
You want to do the next guy?
First,
All right, we'll do Mr. Lockwood, Jason Lee Lockwood next.
Mr. Lockwood?
He's got two. He's got the new judge.
Lockwood.
Oh. There we go. All right. This is,
Yeah, but
they didn't have a yellow. This one?
yeah, that one.
That's the case. All right, this is a new case concerning Jason Lee Lockwood. Sir, you are Jason Lee Lockwood?
yes.
All right, Mr. Sartz, your appearance for the record?
Good afternoon, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. Lockwood. And Your Honor referenced a new case because I believe he also has a warrant for an older case as well.
That's correct. He has a second file that we'll have to address concerning a fail to appear for sentencing.
Okay, thank you, Your Honor. I'm here on both of
think
these
is that-
matters for arraignments. Thank you.
All right. That's fail to appear for,
He's got the paper sentencing.
yeah, drunken pursuit. All right. So, Mr. Lockwood, this is the time that I'll indicate what your charges are in this misdemeanor complaint. So the complaint would indicate that on February 25th, 2023 at 4900 Hughes Road, City of Lansing, Ingham County, State of Michigan, that yourself, Jason Lee Lockwood, did in count 1, did attempt to commit the following list of offense, and the attempt did act towards the commission of that offense. That's an attempted offense, but failed in the preparation, was prevented in the execution thereof. Contrary to the law of the state of Michigan, the offense that was attempted was to assault, batter, wound, resist, obstruct, oppose, or endanger Officer William Turvo and Officer Jeffrey Kurtz, police officers of the Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to the law of the state of Michigan. That's 750.81D, parents 1. It's a misdemeanor, 1 year and or $1,000. Upon conviction of an attempted felony, court shall order law enforcement to collect DNA identification profiling samples. So count 1 is an attempted resisting and obstructing, 1 year and or $1,000. And there's also a count 2, domestic violence, did make an assault or an assault and battery upon Carrie Hyatt, a resident or former resident of his household, or did an individual with whom he had a dating relationship. Contrary to the law of the state of Michigan, that being MCL 750.81 parents 2, there may be restitution ordered in this file if there was damage to the individual's property or physical injury or death to the person pursuant to MCL 780.811A. This is a misdemeanor, 93 days and or $500. A consecutive sentence may be imposed if the assault was committed in a place of confinement. Mr. Lockwood, do you understand the rights that you have? Do you understand the nature of the allegations in this misdemeanor complaint?
Yes.
All right, I'll read you some rights you have in this misdemeanor complaint. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. You have the right for the court to order any witnesses that you may have in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. You also have the right to counsel. In this case, you are represented by Public Defender Jacob Sartz in this matter. Do you plan to seek additional representation from the Public Defender's Office in this misdemeanor file?
Yes.
All right, thank you. I'll indicate yes for the register of actions. Your next hearing date is available by Zoom. It's going to be March 13th, 2023 at 10:30, and that would be in front of Judge Ward. Do you have a current address other than the address of Ms. Hyatt where you can be notified or where the court can get a hold of you with any written materials?
Yes.
And what address is that, sir?
10260 Roberts, Roberts Road. That's Gregory, Michigan, 48137.
And what's the zip code again? 481?
37
All right. Do you have a phone number, sir?
734 657 0012.
Are you on probation or parole?
No, sir.
Are you employed, sir?
No.
Okay, for purposes of this arraignment, I'll enter a not guilty plea. Mr. Sartz, would you like to be heard on bond?
Thank you, Your Honor. Respectfully, and these requests would apply to both files. I'd request the court consider imposing a low cash bond. It's certainly understood that Mr. Lockwood would not be eligible for personal recognizance bond based on the fact he had a previous case that was still open and pending when he picked up these new charges. To his credit, he is able to attend his future court dates. He has connections to the community. He currently has some visual impairments, Your Honor, but it's important to note that he does not need any additional accommodations as it relates to Braille-related notices or anything along those lines. He does have his family in the area, including his parents. So based on the circumstances, I would request a low cash bond for both of these files. Thank you.
Thank you. If you're able to make bond, I'm going to set the following bond conditions. So GPS is to be ordered in regards to the exclusion zone. And the exclusion zone would be the place of the incident in this matter, which would be 4900 Hughes Road. No use of alcohol or drugs. No assaultive behavior. No out-of-state travel. No contact with the victim in this case, who's Carrie Hyatt. And that's to be within 1,500 feet of Miss Hyatt, and that includes school, work, or business. and not to possess a firearm. In regards to this, based on the previous fail to appear and the bond recommendation set by Judge Simmons, who was the sentencing judge for the DV second that was supposed to be sentenced on, it looked like it was being, I don't know what it was pled down to. Disorderly person drunk. It was pled down to disorderly from DV second. Failed to appear on that previous file. I'll let Judge Simmons address any new bond. We'll remand on this case. What's the Judge Ward file? It is a Judge Ward file because it's a DV second. All right. So I'm going to remand for Judge Ward to reconsider bond. She indicated remand on her paperwork. And when she signed it, and I'm not going to overrule that. So bond is remanded on this case. And then you can readdress once you get in front of Judge Ward, who is the sentencing judge, how you want to proceed in regards to asking for a bond on this matter. Anything else for the record, Mr. Sartz, on Mr. Lockwood's case?
Nothing further, Your Honor. Thank you.
Okay, thank you. That's all for the record in this file. And then I have the second file with Mr. Lockwood that we previously discussed, but we'll go ahead and we'll indicate for the record. You have a second file, Mr. Lockwood, for that fail to appear. There was a bench warrant issued on that for fail to appear at sentencing and for the referral to probation on November 8th. That you did not appear was signed by Judge Ward on November 8th. So that is the second bench warrant you had. There was a no contact order in regards to that bench warrant on a Michelle Kozak, not to be within 1,500 feet of Michelle Kozak. So that stays in place along with any other bond conditions that were originally part of the file. Mr. Sartz, your appearance for the record concerning this second arraignment on Mr. Lockwood.
Thank you, Your Honor. Jacob Sartz, the fourth Assistant Public Defender, here on behalf of Mr. Lockwood for this file. He was represented by Scott Nichols from our office, and we will get him new counsel. Mr. Nichols has since moved on to a felony docket, but he will be assigned another district court docket, public defender on this file. Thank you.
All right, thank you. It looks like the same address and information that were really originally placed on the previous file or a part of this file already. So we'll just transfer any address and probation parole. None of that needs to be updated. I'm going to enter automatically. You're entitled to you failed to appear for that in front of Judge Ward. So that's the nature of the allegation, is that failed to appear bench warrant. Mr. Sartz, would you like to be heard on bond on this case?
Thank you, Your Honor. Respectfully, I would request the court consider a low cash bond. However, I presume the Judge Ward has also provided Your Honor with the similar instruction requesting remand. I would note to Mr. Lockwood's credit, as I noted earlier, that he's connections to the community, that he can make his future court dates, that he'll comply with the court's orders. Respectfully, thank you.
Thank you. Since I'm working from Judge Ward's order, and there's an indication on the order that you're to be your bond is revoked and that you are to be remanded, I'm going to remand you to be sentenced on this file in front of Judge Ward, and so you're remanded on this file until further notice. I'm sure it's sensing you can readdress any of the issues that came from fail to appear, but at this point in time, you're remanded for fail to appear until you get in front of Judge Ward. Anything else for the record in docket 22-01165, Mr. Sartz?
Right, Mr. Lockwood, were you trying to say something?
So much for innocent until proven guilty. No.
Well, sir, anyway, nothing further, Your Honor, and
All right. All right, Mr. Lockwood, your next date will be on this file and your new sentencing date in front of Judge Ward. You're all set.
Hmm.
And then I think we have several files. This is the plan, Mr. Starks, is do the several files, and then I'm going to take a break and read the probable cause affidavit on the following case, and then hopefully I'll have the complaint by that time, and then we can arraign that person. Okay.
Sounds good. Thank you.
All right. So we can do Mr. We'll start. Oh, we can do Miss Harrington to do. Is that right?
I believe so.
Yeah, I think we have to do Miss Harrington.
Yep, Miss Harrington.
And then we'll do Mr. Pearl. All right, ma'am, you are Angelica Bethany Jane Harrington.
Yes,
All right. This is the time set for an arraignment in the matter. Mr. Sarts, your appearance for the record.
Good afternoon, Your Honor. Jacob Sarts IV, Assistant Public Defender, here for this appearance and this appearance only.
All right. This is the time set for your arraignment on this misdemeanor case, on this misdemeanor count. Ma'am, I'm going to read you the nature of the allegations that have been brought against you in this case. And then I'll read you some rights you have in this misdemeanor file. All right, ma'am?
okay,
All right. It is alleged that on February 25th, 2023, at 325 North Martin Luther King, City of Lansing, Hingham County, that you yourself, Angelica Bethany Jane Harrington, did make an assault or an assault and battery upon the following person, Julia Beechler, contrary to the laws of the state of Michigan, that being 750.81 parents 1. There's a restitution notice that this offense resulted in damage to another individual's property or physical injury or death. Restitution could be ordered pursuant to 780.811A. This is a misdemeanor, 93 days and or $500. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Do you understand the nature of the allegation brought against you, ma'am?
yes,
You have the following misdemeanor rights in this trial, in this file, and I'll indicate those for the record for you. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. You have the right to have the court order any witnesses you may have in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand your misdemeanor rights in this case, ma'am?
yes,
You also have the right to counsel at this arraignment. You are represented by counsel Jacob Sarts from the Public Defender's Office. Do you plan to seek additional representation from the Public Defender's Office in regards to this file?
yes,
All right. I'll indicate a yes for purposes of the Register of Actions. Your next hearing in this case is set for, it's a regular assault and battery. So you will receive a notice to appear within 48 hours of today. All right, ma'am?
okay,
Okay, so you'll get a notice of when to appear in regards to your next appearance in this case. Since it is not a domestic assault, it is just an assault and battery. Do you have a address for the court other than the place of the offense? So that Scribner Road is a different than the 325 North Martin Luther King. Is that Scribner Road a good place for you to receive any mail or notice from the court?
I would actually like to use 824 Robbins Road. It's my foster parents.
Okay, so you prefer me to use that address?
Yes, please.
Okay, what's that address again, ma'am?
824 Robbins Road, Lansing, Michigan, 48917.
Okay, 824 Robbins Road.
Lansing, Michigan, 48917.
Thank you. And do you have a phone that would be a good place to contact you at?
I do, but it's in the mail. I'm waiting for it in the mail. So I don't know my number yet.
All right. Do you have a number that would work? I can always
Yeah.
put that it's to be determined.
Yeah, it's fine.
All right. Are you on probation or parole, ma'am?
No,
Are you employed?
yes,
And where are you employed?
Marco's Pizza.
I'm going to enter a not guilty plea for purposes of this arraignment. Mr. Sarts, would you like to be heard on bond?
Thank you, Your Honor. Respectfully, I would request a personal recognizance bond on behalf of Ms. Harrington. She has roots in the community. She's not a flight risk at all. She's going to stay with her foster parents, so she'll have a stable place to stay. She has a good job locally in the community, and she'll comply with all the court's orders. Thank you.
Thank you. So I'm going to, ma'am, if you're able to make bond, I'm going to set the following bond conditions. No use of alcohol or drugs. No assaultive behavior. No out-of-state travel. No contact with a victim directly or indirectly. I'm also going to have a no contact. So I'm going to do a no contact in regards to Julia Beechler. There's also a witness in this case. I'm going to make a note, part of the no contact order. So no contact at this time. With Eric Harvey. And no contact with the address of 325 North Martin Luther King.
So what about all my
City of
belongings?
Lansing. So that's no contact, 1,500 feet within the presence of Julia Beecher, Eric Harvey, or the 325 North Martin Luther King address.
All right. What about my belongings?
I will allow a one-time visit with police officer present, and I'll make it a part of the order. So one-time visit with law enforcement to retrieve any of your belongings. And I understand that this came out of a somewhat of a roommate domestic type of situation. So to protect you, you should go in there and have law enforcement present so that you're not in violation in the orders, because it's in the order itself. You're allowed to get your items with law enforcement present and retrieve your items, anything that you have there in order to get your personal belongings. In regards to any bond in this matter, I've had the opportunity to see the bond that was the previous history here. And it looks like there's a felony drug out of 2019, a domestic assault out of 2020, a R&O out of 2020, a retrail fraud out of 2020, and then older domestic assaults and deferred domestic assaults. I'm going to set bond on this case at $5,000, 10%.
Okay.
Anything else for the record, Mr. Starks?
Nothing
And concerning Ms. Harrington?
Nothing further, Your Honor. Thank you.
Thank you. That's all for the record. With your case, Ms. Harrington, you will get a notice to that address on your next date in court. All right.
Okay, thank you.
All right. Thank you. And then all right. So we have 4 files in regards to Mr. Pearl that are all failed to appears. So we'll do Robert Pearl next. All right, sir, you are Robert Pearl.
Yes, sir.
All right, this is concerning docket 22-00813. Counsel, your appearance for the record.
Good afternoon, Your Honor. Jacob Sarts, the 4th Assistant Public Defender, here on behalf of Mr. Pearl. For these appearances only, he's currently represented by Luke Goodrich from our office, and Mr. Goodrich most likely will remain as his attorney record.
All right. So this is the time for the arraignment on the bench warrant. I'll tell you that the nature of the allegations that have been brought against you concerning your bench warrant status. It appears that on October 17th, 2022 at 10 a.m., you failed to appear for a pretrial in front of Judge Simmons. Therefore, a bench warrant was placed for your appearance purposes, and the bond was set by the judge in this case. Sir, do you understand the nature of the allegation brought against you for your failure to appear?
Yes, sir.
All right. Counsel, would you like to be heard on bond? First of all, I have a 310.5 North Magnolia address. Is that still a good address for notice to you, Mr. Pearl?
Yes, sir.
All right. And I have a number of 517-619-7820. Is that still a good number for you?
That's my mom's number. I can receive notice at that number, but I also have a personal cell number.
Okay. So let me put that for the record. What's your personal cell number?
980-990-6586.
All right. Mr. Sarts, would you like to be heard on bond on this?
Thank you, Your Honor. Respectfully, on behalf of Mr. Pearl, I would request the court consider reinstating a personal recognizance bond for him. He will make all his future court dates. He has connections to the community. He's not going to try to flee the area. He understands the importance of showing up for his court dates. He'd like an opportunity to try to work and try to support his family. He has a couple of minor children. He has a job, a steady job, working as a subcontractor in the trades. So he'd have opportunities to work if he's able to get out. And, prior, in fact, his community connections here are quite strong with parents, siblings, and friends in the community. So respectfully, I would request the court allowing him a personal recognizance bond, or in the alternative, a low cash bond. Thank you.
All right, thank you. I'm going to set a low cash bond for your fail to appear. You have multiple fail to appear files. So the $200 PR bond was not a threat on some level for your appearance, but I'm going to set it lower than the judge is requesting. I'm going to set it for $200 cash surety. So that's on 22-00813. Then we have 22-00814. 22-01245. And this, sir, this is also people of the state of Michigan versus Robert Y. Pearl. Mr. Sartz, your appearance for the record.
Good afternoon, Your Honor. Jacob Sartz, the fourth Assistant Public Defender, here on behalf of Mr. Pearl. For this appearance and this appearance only, he's currently represented by Mr. Goodrich on this file as well. And I expect Mr. Goodrich will remain as attorney of record moving forward. Thank you.
All right, thank you. Mr. Pearl, this is the time set for your arraignment on this file. This is I believe this is what started out to be a felony file. No, it's two 1 year's attempted R&O files. And you failed to appear. So the allegation from Mr. Bigelow and Judge Simmons, who signed the warrant, is the defendant failed to appear for pretrial on October 11th, 2022 at 10:30. Do you understand the nature of the bench warrant that was issued by Judge Simmons in regards to your fail to appear?
Yes, sir.
All right. I'm going to indicate for the record, it appears we have a new cell phone, and I'll have that transferred. This is another fail to appear in front of Judge Simmons that bond was set on. It looks like. Mr. Sartz, would you like to be heard on bond in this matter?
Thank you, Your Honor. I would echo the comments I made previously as it relates to Mr. Pearl. He has deep roots in the community. He has a stable job. I'll make sure he makes all his future court dates. Thank you.
Thank you. I'm gonna reiterate the same bond conditions that were originally set, including the no use of drugs or alcohol, no assaultive behavior, no out-of-state travel, and no firearm. Bond was originally set. I have it. Originally set was a $500 PR bond, and then I have a $500 10% bond. I'm going to indicate for the record that this bond will be issued at $500 10%. $500 10% on this file. You probably want the yellow thing too. And then on the next file, Mr. Pearl, we have docket. I'm not even sure what this is. 22-00030. Let me make sure I have the right file. Not right.
Yep.
All right. So we're on the record, Mr. Pearl. Once again, you are Robert Pearl, the fourth.
Yes.
All right. This time set for arraignment. Counsel, your appearance for the record.
Good afternoon, Your Honor. Jacob Sartz, the fourth Assistant Public Defender, here on behalf of Mr. Pearl. For this appearance only, and Mr. Goodrich is Mr. Pearl's attorney record on this file, and I anticipate Mr. Goodrich will remain as his attorney. My apologies, Your Honor. Do we have a court date, the next court date for all these cases? I believe there's five.
All this indicated on this traffic stuff is that they'll get notice to appear within 48 hours of the arraignment.
Okay.
So I don't have a date certain right now.
Thank you, Your Honor. So you understand what that means, Mr. Pearl?
Yes.
Okay, thank you.
All right, thank you, Mr. Sartz. I think all these files are the same. I'll check the next one too, but Mr. Pearl, you understand that a bench warrant was issued concerning your failure to appear on October 17th, 2022 at 10 a.m. in front of Judge Simmons. That is the nature of the bench warrant that's been brought against you. Do you understand that, sir?
Yes.
And I'm going to have your personal cell transferred to this file. In the other cell phone number and the address are the same. So your next date will be mailed to you within 48 hours of today. Mr. Sarts, would you like to be heard on bond on this fail to appear? It's a traffic offense, I think.
Thank you, Your Honor. I would just echo my previous comments regarding bond. He does a good job and plenty of connections to the community. He'll make sure he shows up at all his future court dates. Thank you.
All right. The bond was originally set at a 200 PR bond, and then at the fail to appear, Judge Simmons set a 500 cash or surety. I won't overrule Judge Simmons. So it's $500 cash or surety on this file. If you're able to make bond, you're under the same bond conditions that were previously set, which includes appear at any examination, do not leave the state of Michigan without permission of the court, do not commit any crime, immediately notify this court in writing if there's a change in address or telephone, and do not use alcohol, marijuana, or a controlled substance. You'll receive a date to appear within 48 hours of this date of arraignment. Anything else on this file, Mr. Sarps?
Nothing further, Your Honor. Thank you.
All right, that's all for the record in that file. And then finally, we have a file for fail to appear on another traffic matter. So, sir, once again, you are Robert Y. Pearl IV?
Yes.
All right. And this is the time set for arraignment. Counsel, your appearance for the record.
Good afternoon, Your Honor. Jacob Sarts IV, Assistant Public Defender, here on behalf of Mr. Pearl for this appearance and this appearance only. He's currently represented by Luke Goodrich from our office, and I expect Mr. Goodrich will remain as the attorney record for this file moving forward.
All right. And this is on docket 22-00031. It's another traffic file. All right. So there's another ticket with it, 21L2702041. It is also a companion ticket on this file. Sir, you understand that this is the time for an arraignment. I will indicate the allegations that have been brought against you. Allegation on this file and the accompanying ticket that you failed to appear for pretrial on October 17th, 2022 at 10 a.m. Do you understand the nature of the allegations that have been brought against you, sir?
Yes.
All right. I have the prior cell phone, and I'm going to indicate transfer the personal cell phone. I don't have any traffic on this one.
That's the prior cell phone is my mom's cell phone number. So I
All
would
right.
like that to stay on cases.
All right, I left it on there, so they're both, and then we'll transfer your personal cell phone number to be as a backup number to that one.
Okay.
All right. So similar to the previous file, this is for fail to appear. A notice to appear will be mailed within 48 hours of your date of arraignment, which is today. Mr. Sarts, would you like to be heard on bond again? I know you've made the similar argument several times now.
Thank you, Your Honor. And I would just echo my previous comments as it relates to bond. And just to clarify, Your Honor, there's another file that accompanies this one, and is that the allegation of driving an unregistered vehicle, which is a misdemeanor? Okay,
Correct. Yeah.
thank you.
So that second ticket, 21L2702041, is driving an unregistered vehicle. It's also a misdemeanor, and it's also accompanying this no insurance file in which both failed to appears were on. Do you understand that, Mr. Pearl?
Yeah.
All right. Bond was set by Judge Simmons at $500 cash or surety. I'm not going to overrule that at this time. I'll indicate that if you're able to make bond, the original bond conditions are still in place. So to personally appear at all court hearings, abide by any judgment entered by the court, do not leave the state of Michigan, do not commit any crime while released, immediately notify the court if there's a change in address or phone number, and do not use alcohol, marijuana, or any illegal controlled substance. Yeah, I've set bond on the ticket for the unregistered. So she only set it on the file.
There should be a warning.
So bond is set on the other one. It was set by Judge Simmons at 150 cash or surety. So it would be 500 on the actual file, cash or surety. And 150 on the accompanying ticket, cash or surety, per Judge Simmons. Anything else on this no insurance file of 22-0031 or the accompanying ticket of unregistered on 21L2702041?
Nothing further, Your Honor. Thank you.
From you. All right, thank you. Mr. Pearl, you should be all set, okay, sir? So Mr. Sartz, let me check to see the status. I saw Miss Eisfelder came in, so I'm assuming I'm sorry, did I say Miss Eisfelder? Miss Eisenhut came in. I'm assuming she came in on the SOS case. I'll check my iPad and see what the affidavit and the warrant looks like on that one, okay?
Thank you, Your Honor.
All right, thank you. So cocaine.
LPD,
Yes,
judge is reviewing the last affidavit as we speak. I'm not 100% sure if we have the complaint yet. And then for Mr. Pearl, for the ticket, There
Yes.
was not bond paperwork in the file, so I did it like we were here, like a jail clerk. So I'll put that
Okay,
on the correct
yeah.
side of the file.
We were gonna, yeah, because we didn't know that they ran them together in that file.
Yep, no problem. I just wanted to let you know what I did so you weren't wondering what I did.
Okay, sounds good, thanks.
Thanks.
Ms. Eisenhut, how are you?
Good afternoon, Your Honor. I'm doing well. How about yourself?
Pretty good. Pretty good.
Uh-oh, that's not a good sign when Teddy's here every day.
How are ya?
Well, at least I know there's 3 people who are working on Sunday.
Yeah. It's been a marathon today. I'm sure it has over here too.
Yeah, everywhere,
So,
everywhere.
does this involve Mr. Handsome?
Yes, sir.
Yes.
Okay.
Yep. So it's Jail, are you ready on Mr. Handsome?
Yes, we are, Your Honor.
All right, thank you. All right, sir, you are Marwan Hassan Handsome.
Yes, sir.
All right, this is the time set for an arraignment on these felony charges. Mr. Sartz and Ms. Eisenhut, your appearances for the record.
Good afternoon, Your Honor. Theodora Eisenhut on behalf of the people.
Good afternoon, Your Honor. Jacob Sartz IV, Assistant Public Defender, here on behalf of Mr. Handsome for this appearance and this appearance only is arraignment. Thank you.
All right, thank you. And Mr. Handsome, this is the time set for arraignment on these counts. I believe there's 25 counts that I'll go ahead and indicate the allegations of the charges that are made against you. And then some of the rights you have in these felony matters. Do you understand that, sir?
Yes, sir.
All right. The allegation it indicates that on or about February 24th, 2023, at 6337 Lerner Way, City of Lansing, Ingham County, State of Michigan, yourself, Marwan Hassan Handsome, did in count 1 possess with intent to deliver 50 grams or more, but less than 450 grams of a mixture containing the controlled substance cocaine, contrary to the laws of the state of Michigan. That's MCL 333.7401, 2 parents 2A3I. Felony 520. This is a felony 20 years and or $250,000. A consecutive sentencing may be imposed for any other felony conviction. On count 2, did carry or have in your possession of a firearm, to it a handgun or a rifle at the time you were committing or attempted to commit a felony, to it possession with intent to deliver cocaine 50 grams to 449 grams, contrary to the law of the state of Michigan. That's MCL 750.227B. It's a felony 2 years to run consecutive with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of weapon or device pursuant to MCL 750.239. In count 3, did possess with the intent to deliver the controlled substance of fentanyl, contrary to the law of the state of Michigan, that MCL 333.7401, parents 2, parents B, parents 2I. It's a felony 7 years and or $10,000. In count 4, did carry or have in his or her possession a firearm, a handgun, or rifle at the time he/she committed or attempted to commit a felony, to wit, possession with intent to deliver Schedule 1, 2, and 3, contrary to the law of the state of Michigan. That's MCL 750.227B. It's a felony 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of weapon of device pursuant to the laws of the state of Michigan. Did in count 5 possess or receive a firearm when ineligible to do so because he or she had been convicted of delivery of manufactured controlled substance, cocaine, heroin, or other narcotic, in parentheses, less than 50 gram, was specified and was not eligible and had not eligibility to meet those requirements had not been met, contrary to the law of the state of Michigan, that being MCL 750.224F. That's a felony 5 years and or $5,000. More mandatory forfeiture of weapon or device pursuant to MCL 750.239. In count 6, did carry or have in his or her possession a firearm, to it a handgun and or rifle at the time he committed or attempted to commit a felony, to it felon in possession, contrary to 750.227B. That's a felony 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of weapon or device pursuant to MCL 750.239. Did in count 7, did possess or receive a firearm when ineligible to do so because he had not been convicted of because he had been previously convicted of delivery, manufacture, controlled substance, parents cocaine, heroin, or other narcotic, less than 50 grams, a specified felony, and the requirements for gaining eligibility had not been met, contrary to the law of the state of Michigan, that being MCL 750.224F. That's a felony, 5 years and or $5,000. Mandatory forfeiture of weapon or device pursuant to the law of the state of Michigan. In count 8, did carry or have in your possession a firearm, to it a handgun and or rifle at the time you committed or attempted to commit a felony, to it felon in possession, contrary to the law of the state of Michigan, that being 750.227B. That's a felony, 2 years consecutively and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device pursuant to the law of the state of Michigan. In count 9, did possess or receive a firearm when ineligible to do so because he had not been convicted of, he had been convicted previously of deliver, manufacture, controlled substance, in parents cocaine, heroin, or other narcotic, less than 50 grams, a specified felony, and the requirement for regaining eligibility had not been met, contrary to the law of the state of Michigan, that being 750.224F. That's a felony, 5 years and or $5,000. Mandatory forfeiture of weapon or device pursuant to MCL 750.239. In count 10, did carry or have in possession, his possession, a firearm, to it a handgun or rifle at the time he committed or attempted to commit a felony, to it felon in possession, contrary to the law of the state of Michigan, that being 750.227B. That's a felony, 2 years consecutively with and preceding any term or imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon may be sought under MCL 750.239. In count 11, did possess or receive a firearm when ineligible to do so because he had previously been convicted of delivery and manufacture, controlled substance, cocaine, heroin, or other narcotic, in parentheses, less than 50 grams, a specified felony, and the requirement of regaining eligibility had not been met, contrary to the law of the state of Michigan, that being 750.224F. It's a felony, 5 years and or $5,000. Mandatory forfeiture of weapon or device pursuant to the law of the state of Michigan under 750.239. In count 12, did carry or have in your possession a firearm, to it a handgun or rifle at the time he committed or attempted to commit a felony, to it felon in possession, contrary to the MCL 750.227B. It's a felony, 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device pursuant to MCL 750.239. Did in count 13, did possess or receive a firearm when ineligible to do so because he or she had been convicted of delivery or manufacture of controlled substance, parent cocaine, heroin, or other narcotic, end of parent less than 50 grams, a specified felony, and the requirements for regaining eligibility had not been met, contrary to the law of the state of Michigan, that being 750.224F, that being a felony, 5 years and or $5,000. Mandatory forfeiture or weapon or device pursuant to MCL 750.239. Did in count 14, carry or have in his possession a firearm, to it a handgun or rifle at the time he committed or attempted to commit a felony, to it felon in possession, contrary to the law of the state of Michigan, that being 750.227B. It's a felony, 2 years consecutively and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device pursuant to MCL 750.239. In count 15, did possess ammunition when ineligible to do so because he had been convicted of delivery, manufacture, controlled substance, parents cocaine, heroin, or other narcotic, into parents less than 50 grams, a specified felony, and the requirement for regaining eligibility had not been met, contrary to the law of the state of Michigan, that being 750.224F, parent 6. That's felony, 5 years and or $5,000. Mandatory forfeiture of weapon or device pursuant to MCL 750.239. Didn't count 16, carry or have in his possession a firearm, to it a handgun and or rifle at the time he committed or attempted to commit a felony, to it felon in possession or ammunition, contrary to the law of the state of Michigan, that's 750.227B. It's a felony, 2 year consecutive with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device pursuant to MCL 750.239. In count 17, did possess a muffler or silencer contrary to MCL 750.224 parents 1, that being a felony, 5 years or $2,500. Mandatory forfeiture of weapon or device pursuant to 750.239. Count 18, did carry or have in his possession a firearm, to it a handgun or rifle at the time he committed or attempted to commit a felony, to it, a dangerous weapon miscellaneous, contrary to the law of the state of Michigan, that being 750.227B. That's a felony, 2 year consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture, weapon or device under MCL 750.239. Didn't count 19, possess a short-barreled rifle, contrary to MCL 750.224B. It's a felony, 5 years and or $2,500. Mandatory forfeiture of weapon or device pursuant to MCL 750.239. In count 20, did carry or have in his or possession a firearm, to wit a handgun or rifle at the time he committed or attempted to commit a felony, to wit a possession of a short-barreled rifle or shotgun, contrary to the law of the state of Michigan, that it being MCL 750.227B. That's a felony, 2 year consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of weapon or device pursuant to MCL 750.239. Didn't count 21, possess a device that is designed or intended to be used to convert a semi-automatic firearm into a fully automatic firearm, contrary to the law of the state of Michigan, that being MCL 750.224E. It's a felony, 4 years and or $2,000. Mandatory forfeiture of weapon pursuant to MCL 750.239. Didn't count 22, carry or have in his possession a firearm, to wit a handgun or a rifle at the time he committed or attempted to commit a felony, possession of device to convert a semi-automatic to an automatic being the felony, contrary to 750.227B. That's a felony, 2 years consecutive with and preceding any term of imprisonment for the felony or attempted felony conviction, mandatory forfeiture of weapon of device and pursuant to MCL 750.239. Didn't count 23, knowingly or intentionally possess a controlled substance, oxycodone, contrary to the law of the state of Michigan, that being 333.740, parents 2, parents B, parents 2I. It's a felony, 2 years and or $2,000. Didn't count 24, carry or have in his possession a firearm, to wit a handgun or a rifle at the time he committed or attempted to commit a felony, to wit possession of analogs, contrary to MCL 750.227B. That's a 2 year consecutive and preceding any term of imprisonment imposed for the felony or attempted conviction or the attempted felony conviction, mandatory forfeiture of weapon or device pursuant to 750.239. In count 25, did assault, batter, wound, resist, oppose, obstruct, or endanger Officer Ethan Merlick, a police officer of Lansing Police Department. The defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D, parents 1. It's a felony, 2 years and or $2,000. A consecutive sentence may be imposed under 750.506A if the assault was committed in a place of confinement, or MCL 750.81D6 for another violation arising out of the same transaction. There is a habitual offender fourth offense notice, sir. So take notice the defendant was previously convicted of 3 or more felonies or attempt to commit felonies in that or about January 21st, 2004. He was convicted of the offense of possession of controlled substance, cocaine, heroin, or other narcotic, less than 25 grams in violation of MCL 333.74032A5 in the 30th Circuit Court of Ingham, State of Michigan, and or about October 5th, 2009. Here she was convicted of the offense of delivery, manufacture, controlled substance of cocaine, heroin, or other narcotic, less than 50 grams in violation of MCL 333.74012A4 in the 9th Circuit of Kalamazoo, State of Michigan. And on or about October 7th, 2010, he or she was convicted of the offense possession, controlled substance of cocaine, heroin, or other narcotic, less than 50 grams in violation of MCL 333.74012A4 in the 30th Circuit Court for the Ingham County, State of Michigan. Therefore, defendant is subject to the penalties provided by MCL 769.12. That's penalty is life if primary offense has been 5 years or more, 15 years of less if primary offense has penalty under 5 years. The maximum penalty cannot be less than the maximum term for a conviction. Sir, do you understand the 25 counts and the offense notice that the court has read?
Yes, sir, I do.
All right. So I'm like, so your dates on this hearing will be, concerning these 25 counts and the habitual notice, will be Next date will be by Zoom, or is capable of being by Zoom.
March 10th.
But your probable cause conference is March 10th, 2023 at 8:30. And that's in front of myself. And then your preliminary examination is scheduled in person on March 17th, 2023 at 8:30.
In front of you, sir, too.
So yes, also in front of myself in regards to the March 17th date. That's correct. So March 10th for probable cause conference and March 17th for preliminary examination.
I understand, Your Honor.
Do you have a current address for the court's file, sir?
Yes.
Is that the Otter Road address?
Yes, sir.
All right, so I'll indicate 5225 Otter Drive, Lansing, Michigan, 48910. Do you have a phone number for the
48917.
court's file? So
48917.
say it again.
48917.
48917. All right, thank you. And do you have a phone number?
517-894-4576. But I ain't getting out of here. I'm gonna be in jail. I can't bind out. I don't got no money.
So 517-894-4576. Are you currently on parole or probation, sir?
No, sir.
All right. Are you employed?
Yes, sir. I'm a barber.
And where are you a barber at?
Big B's barbershop on Mount Hope. And I do house
All right.
calls. I pay
All right.
child support. I have 6 kids. I pay child support.
I will automatically enter a not guilty plea for purposes of this arraignment.
Yes,
I will start with the people and then go to the defense in regards to anything you want the court to consider on bond. Ms. Eisenhut?
Thank you, Your Honor. Your Honor, the people did submit a bond form with this case. However, I would like to point out several of the factors pursuant to Michigan Court Rule 6.106F, starting with 1A, which is the defendant's prior criminal record. Your Honor, the people are requesting a high bond or high cash bond in this matter without surety, and the defendant's criminal history weighs strongly in favor of a high cash bond. Beginning in 2004, there are a number of felony convictions, Your Honor, not only for delivery manufacture of drug offenses over a course of years, but also for gun charges, Your Honor, as well as fleeing and eluding. And I'll talk a little bit more about the fleeing and eluding and the relevance of that here in a moment. But Your Honor, moving on to the defendant's record of appearance or non-appearance at a court proceedings or flight to avoid prosecution, the people are unable to provide specific information with the defendant's history as far as proceedings are concerned. But I can say with this case, he was interviewed by officers, and he did indicate that he was intended to leave the state upon his release. As a matter of fact, he said within 48 hours of his release from custody. In addition, this defendant fled officers on their initial contact with him in this case. And further, Your Honor, the defendant does have another number of violations that are documented in his criminal history for probation violation, although those are unclear whether or not they are with regard to absconding. And finally, Your Honor, circling back to the conviction for fleeing and eluding, as well as a number of conviction or dismissed counts for fleeing and eluding, resisting, obstructing arrest throughout his criminal history. Your Honor, it is very clear that this defendant is a flight risk, even before we consider the seriousness of the charges in this case. Further, Your Honor, moving on to his character for dangerous. Our dangerousness, Your Honor, there were no less than 5 different weapons that were located, and majority of them were loaded throughout the home that the defendant was living in. This was in a home where they were in various locations. There were a number of children that were also located in this address, Your Honor, most of them being under the age of 13. That had easy access to these things, as well as a silencer, a switcher, and a short-barreled shotgun. Further, these are charges that involve the possession with intent to deliver and numerous narcotics. And so, Your Honor, we would indicate that these all goes towards the defendant's reputation for dangerousness in this case, which then leads us to the seriousness of the offenses here. The presence or absence of threats and the probability of conviction. The items in this case, Your Honor, were all collected and are currently being processed, as well as the defendant having made admissions to having purchased firearms, at least 2 of the ones that were located in the house, as well as directing officers to where the narcotics were, or some of the drugs were located. These are serious charges. With the 4th habitual offender notice, they carry up to 20 years of incarceration, with the felony firearm counts carrying consecutive 2 years for each offense. This defendant, again, has every incentive to flee. And further, the defendant did make clear to officers that he felt, or made it clear to officers that the individual that he felt was responsible for his arrest in this case was quote unquote dead. And when advised of the seriousness of a statement of this nature, the defendant laughed and then told the officer, "You didn't hear that then." So there is an obvious presence of threats in this case, not idle threats, given the number of firearms that were located in this house, but also this would indicate the defendant's dangerousness to the community itself. And so for all of these reasons, Your Honor, the people are requesting a high cash bond in this matter with no surety to protect the public, the community, and also to ensure the defendant's hearing at our future court proceedings. The people would ask that if the defendant is able to post a bond in this case, or does post a bond in this case, that a GPS tether requirement be added with curfew. If in addition, that there be a requirement that there be no out-of-state travel and no contact with any named witnesses in this case. Thank you, Your Honor.
Mr. Sart's response.
Thank you, Your Honor. Respectfully, on behalf of Mr. Handsome, the defense would disagree with the people's characterization and further would respectfully note that those are only allegations and hearsay and other statements that were not sworn to under oath for the purposes of today's proceedings. And as it relates to Mr. Handsome's alleged statements, again, these are just what the prosecutor is alleging only and not based on any sworn statements to that effect for the purposes of these proceedings or sworn testimony. I would note, Your Honor, that Mr. Handsome is presumed innocent of these charges. These are just allegations at this stage. This is the initial arraignment. He has his rights during this process. The defense is requesting a reasonable cash bond here of the lower variety. The basis for that, Your Honor, is the anticipated timeline that would it take to get a trial like this potentially to a jury trial in the county, given the fact that we're still behind and still working through a very complicated court schedule. If the matter gets bound over, Your Honor, he could easily be sitting in jail for a year or longer before he sees a trial date on these allegations. And Mr. Handsome has his rights. He has connections to the community. His mother lives here. He has a job in the community. He has children that he provides support for. Respectfully, the defense would disagree with the characterizations by the people that he's some type of flight risk or that he's any alleged threat to any witnesses or anything else. On the contrary, Your Honor, Mr. Handsome has deep roots to the community. He'd make sure he complies with all the court's orders. He'd make sure that he shows up to his court dates. He understands the importance of doing small things and important things like reporting to pretrial services. He certainly understands the value of following with the court's orders. He's been under the court's supervision before, and he understands the rules quite well at this point. So Mr. Handsome, I would request the court consider a low cash bond here. And this is going to be a very complicated case. It's going to take a long time to work through. And to his credit, he does have sufficient contacts and a job in the area with plenty of folks who can help keep track of his location. So for the reasons stated, Your Honor, I would respectfully request the court set a low cash bond for Mr. Hanson. Thank you.
All right, thank you. Ms. Eisenhunt, any response? And when you're indicating a high cash bond, what number are you looking at? And also, I'm trying to consider, based on what I've seen in the prior history, why a remand is not being argued.
Your Honor, essentially with regard, I'll start with your second question first.
Okay.
With regard to whether or not a remand is being requested. Your Honor, looking at Michigan Court Rule 6.106, I believe that if the people were able to argue no bond, that would be something that they would do. I think because of the nature of the charges, I don't believe that any of the charges that have been charged in this case fit within the statutory requirement. And I am rambling because I'm trying to find the section right now.
Yeah, I don't see any of these. I see multiple gun charges and drug charges. I don't see anything of an assaultive nature, so to speak of.
Yes, Your Honor. And so while the defendant does have assaultive priors, my understanding is that under pretrial release, it can only be denied if the defendant is charged with murder or treason, which is clearly not here, but also that a violent felony was committed, and that he was on probation or parole at the time, and that during the 15 years preceding, that he had been convicted of 2 or more violent felonies under the laws of this state. And I believe that violent felony is defined here, Your Honor.
Right.
Mm-hmm.
So when you're requesting a high bond,
Yes,
what in the nature are you? How high, I guess, is what I'm asking.
Your Honor, the people at this time are requesting something in the range of 80,000 or more cash.
Okay. All right. I understand. All right. So if bond is able to be met in this case, the court will indicate the following orders.
Can I say something, sir? Or no?
Not at this point. Not at this point. And then you probably should talk to Mr. Sartz for anything else you want to say, especially in regards to the facts of this case. I'll leave that, but let me get through. If bond is able to be made, I'm ordering the following conditions: no use of alcohol or drugs, no assaultive behavior, no out-of-state travel, no possession of a firearm, report to pretrial services within 48 hours, Mr. Sartz, did you want to say anything on behalf of your client? He says he wants to talk, and I just want to make sure he knows the rules.
Thank you.
Rules, sir.
Yeah, if I could just have a brief moment with him in a breakout room, I would like the opportunity to talk to him briefly and perhaps address his concerns before we continue on. Thank you.
All right, I think that would be fair considering this case. And so we're gonna build a breakout room, and then we're gonna put you both in a breakout room.
Thank you, Your Honor.
I gotta go talk to my attorney. Can I talk to him? Where do I talk to him? Leave here? Just be right here. Right now? Just wait.
Yeah, we're gonna put you in a breakout room, Mr. Hanson.
All right. And my back is killing me right now. Oh, this is just, oh my God.
And then Ms. Eisenhunt, we'll just stand by when they come out. I just want to make sure that that he doesn't say anything that he's not supposed to.
Certainly, Your Honor.
Ms. Eisenhunt, I have one question.
Certainly,
And I'll put this on the record with counsel. My only question for you is, can I just do a cash bond in this case? I think I have to set a surety.
can I have a moment,
think-
Your Honor?
You can,
Oh,
because I think legally, I don't know if I can just set a cash bond by itself. I think I have to include a surety, cash or surety.
I think
So if you can find me that answer, I would appreciate it.
I'm on it. Thank you, Judge.
Thank you.
Thank you, Your Honor. We're ready to finish.
All right, just off the record, Mr. Sartz, I asked a question in this case. Can I only set a cash bond? Does any bond I have to set be surety in nature? I don't know if I'm able to just set a cash bond on this. Did you have, Ms. Eisenhunt, did you have any, or Mr. Sartz, do you have any comment on that?
Your Honor, I would respectfully request a surety bond or even a 10% bond. But certainly I'm not, I would have to do some research, Your Honor, but a cash bond would quite frankly be, he's indigent, Your Honor. He's made that point very clear.
Right.
I'll reiterate my request for a reasonable bond, preferably a surety or 10% bond, Your Honor.
All right, Ms. Eisenhunt?
Thank you, Your Honor, and I appreciate a moment for to look into this. And reading the court rules, Your Honor, it does indicate that if money bond is set, that there be an option for the defendant. I have certainly seen cases where a cash bond is set, but I cannot
Right.
provide the authority to this court provide authority for
Right.
that to the court at this time. The people would simply ask that if this court is going to consider a cash surety bonds, that the seriousness of the case, as well as the other factors that the people have argued previously, be taken into account in setting that amount. Thank you, Your Honor.
All right, thank you. I'm going to indicate for the record, I've considered this. They are counsel's right. They're all new allegations. They're all in the nature of drugs and firearms. They are not assaultive in nature. There is an extensive criminal history dating back to October 2002, which is a felony controlled substance. There's also a CCW out of 2004. It looks like a flee and elude, an attempt flee and elude out of 2005. Another flee and elude out of 2005. Those might be the same. There's also a 7-year imprisonment under a flee and elude that was nolly-prossed, but then they were one sentence on a federal charge. I have the 4th habitual notice. I have another delivery out of 2009. So I have somewhat of an extensive criminal history. And I understand that these are allegations, but at this time we can revisit any bond at the preliminary examination or the probable cause conference that is in my purview. But I'm going to set bond because of the extensive criminal history, some of the threats made to other witnesses, and the 25 counts and habitual. I'm going to set bond at $250,000 cash or surety. Anything else for the record in concerning Mr. Handsome, Mr. Sartz?
Nothing further, Your Honor. Thank you. Mr. Handsome, that's
Okay.
cash or surety on that bond amount.
So it's 250,000 cash or surety. Ms. Eisenhunt, anything else on the record?
Your Honor, the people had nothing further other than, and I apologize if I missed this. With respect to the people's request for tether, is that something the court is willing to consider?
It is. I'm willing, since I'm not remanding or indicating I will indicate that tether be. And do you have so tether be a part of the order?
Your Honor, may I just be heard briefly?
Sure, you may.
Thank you. If Mr. Hanson is going to put up $25,000, which would what he would have to pay potentially to hire a bondsman, respectfully, given that large sum of money, would that be a sufficient enough deterrence without the need further for a tether or anything along those lines, Your Honor? That's $25,000 at best if he hires a bondsman. That's also the potential for a $250,000 lien against Mr. Hanson if he ever forfeit that bond. That's a pretty sizable deterrence, Your Honor, respectfully.
It is. And I understand that, Mr. Sarks, based on the drug delivery charges and the amount of weapons offenses involved, I believe if Mr. Hanson is able to make bond, and I'm uncertain if he is, that he should be on GPS tether to the court and to any in respect to any location that he proceeds to, because of the prior criminal history and then the following 25 complaints and life habitual. So I think this is reasonable given the circumstances of the case. So yes, I do order GPS tether as a part of this. Anything else, Ms. Eisenhut?
No, thank you, Your Honor.
All right, Mr. Hanson, your probable cause conference is March 10th, 2023, and your preliminary examination is March 17th, 2023. Those will both be in front of myself. That's all for the record in the file. Thank you for your appearance today.
Thank you,
Thank
Your
you,
Honor.
Your Honor.
So $25,000. Hold on. Thank you, Your Honor.
Thank you. Have a nice week. Try to enjoy whatever's left of your Sunday.
Thank you, Your Honor. You as well.
Thank you, Your Honor. Is that all? That's our last one, correct?
That's it. That's all the files I got. I can't do anything else.
Okay. Thank you, Your Honor.